Okay, I think we're up to episode 4 now, and we'll get right on with whatever their next claim was. Um, Paragraph 13. Whereas the board finds that Paul Johnson's complaints are actually allegations that the chief appraiser's determination was wrong and not properly a complaint that the chief appraiser acted illegally or without any legal authority, although Paul Johnson mischaracterizes the complaints as illegal and fraudulent. And they cite to another case that really doesn't have anything to do with what we're talking about, uh, which this case they cited to uh, has nothing to do with my statements or with this situation. It actually dealt with it was a case was in court, and it dealt with uh, who was sued, not whether an appraisal district's policies were lawful. Anyhow, my comments were about district policies, not about any particular property classification in a lawsuit. Uh, Mine are just about the policies of the appraisal district. And I showed you that they're illegal and fraudulent. I showed you the productivity calculations they made for bees. Here's all these uh, lease rates that they published for different years for different types of properties, cash lease calculations. And I knew there were no leases for income to the landowner. So I made a public information request. Here it is. Show me the leases that you got those numbers from. And their response was specific documents subject to the request do not exist, which is their confession that they just made them up. But they're required by the law. Here's the law. They're required by the law to use lease rates. Chief appraiser shall calculate net land by considering the income that would be due to the owner of the land under a cash lease, share lease, or whatever lease arrangement is typical in the area for that category of land. They claim the comptroller's manual says, oh, they can use some other method, but the comptroller's manual, here's the comptroller's manual, actually says they should not use this other method as a substitute for the cash lease and share lease methods. The law specifies the lease methods that may be used. So all this claiming that I mischaracterized something as illegal or fraudulent is just not true. And but all of those board of directors members were happy to sign on to this, and they hadn't seen this before. They had no idea what it said until it was put before them at the hearing. It wasn't on the agenda, and I objected that all they had on the agenda is some discussion about censure, and it wasn't about who's being censured, what it's for, no specifics, and that it was about a resolution for censure, and there was no resolution attached. Nobody knew what it was. Anyhow, let's go on to the next one. Whereas in the February 5th, 2025 YouTube video, Paul Johnson further accuses the chief appraiser of the criminal offense of tampering with a governmental record for allegedly knowingly making a false entry in a governmental record when determining a lease rate in the district's productivity standards. Well, I showed you the law, sure enough, and I showed you her confession that she made this governmental record, and she put these lease rates on there, and then I showed you her confession that no, there were no leases that those lease rates came from. So I did accuse her of the criminal offense of tampering with a governmental record. Um, and I've showed you the actual documents showing you that she did it. Okay, one more paragraph. Whereas the board finds that Paul Johnson's complaint is without any merit and after consultation with legal counsel finds that the chief appraiser has the authority to determine lease rates and must use alternative methods when leases are not available. Texas Comptroller Manual for the Appraisal of Agricultural Land, page 29. At its core, Paul Johnson's allegation of criminal behavior is actually simply a claim that he does not agree with the lease rate. He simply chooses to fabricate malicious allegations with callous disregard for the truth of the matter or the injury he may cause. Well, I've showed you the what I complain about them tampering with governmental document, making illegal and false practices and procedures. I've showed you the documents where that exists. That does happen. And earlier on, when they said, we don't know of anything illegal that has ever happened, I've showed you why they don't is because they refuse to let it be discussed in their public meetings. When I made the statement that they knowingly made a false entry in a governmental record, it was based on the district's own publication of their fabricated lease rate data in an official productivity standards document. And that document is a governmental record by definition. And knowingly entering false information into it meets the statutory description of tampering with a governmental record under the Penal Code. So the statement was therefore grounded in documented facts, not made with malice. But none of this stuff that says in this censure has any documentation or grounded. When they try to put some documentation saying that the Comptroller's Manual for Appraisal of Agricultural Land allows them to use alternative methods, that's just not true. Here is the Comptroller's Manual. They should not use this other method as a substitute for the cash or share lease methods. The law specifies the lease methods that may be used. There is no question. I've documented. So this about me simply choosing to fabricate malicious allegations with callous disregard for the truth, I don't even have to make unsupported documentation. I've showed the actual documents. There's no question. I show you in black and white what she did, and I show you in black and white what the law is that says she can't do it. And then the repeated claim that it acted after consultation with legal counsel, as if that somehow or another makes it good or better than my opinion or better than my documents. Every trial involves counsels on both sides, and one side is inevitably wrong. Legal advice has meaning only when it's supported by documented proof. In this case, counsel has provided none. The counsel did not provide any actual lease rates and no legal authority that they could contradict the statutory requirement to base productivity values on existing lease rates, as is reaffirmed right in the Comptroller's Manual on page 54 that I showed you underlined. Relying on page 29 while ignoring the controlling instruction later in the same manual demonstrate that this justification cannot be relied on without evidence. So anytime they say consultation with legal counsel, we know that after consultation with legal counsel, they have said things that are wrong or been legally counseled to say things that are wrong, like the manual allows them to make methods other than lease rates, and they claim the legal counsel told them that. Well, all that tells you now is anytime they say after consultation with legal counsel, you cannot count on it being true. Because we can see right here that the legal counsel counseled them to say that they can use alternative methods, and that is just not true. So we'll end this episode here and have another episode soon.